The Judiciary Committee will please come to order, a quorum being present. Without objection, the chair is authorized to declare a recess at any time. Pursuant to Committee Rule 2 and House Rule 11, Clause 2, the chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which, excuse me, for which a recorded vote for the ayes and nays are ordered. I would like to remind members that we've established an email address and distribution list dedicated to circulating amendments, exhibits, motions, or other written materials that members might want to offer as part of our markup today. If you'd like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as possible, as quickly as we can. I would also remind all members that guidance from the Office of Attending Physician states that face coverings are required for all meetings in an enclosed space, such as the committee markups, except when recognized to speak. Finally, I would ask all members, both those in person and those appearing remotely, to mute your microphones when you are not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. Pursuant to notice, I now call up H.R. 2377, the Federal Extreme Risk Protection Order Act of 2021, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2377, to authorize the issuance of extreme risk protection orders.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 2377, the Federal Extreme Risk Protection Order Act of 2021, is an important measure to help address gun violence in America. The bill authorizes federal courts to issue an Extreme Risk Protection Order, or ERPO, temporarily removing firearms from a person in crisis and preventing them from purchasing firearms after making a determination that there is evidence demonstrating that the person poses a significant danger of injuring himself, herself, or others. We know that extreme risk laws save lives. We have witnessed their effectiveness in state after state, beginning in 2016 when California passed the first such law. Since then, 18 other states and the District of Columbia have enacted similar laws. Our consideration of this federal mechanism today is an explicit acknowledgement that gun violence and mass shootings unfortunately have no bounds. Every jurisdiction in this country has been touched by gun violence. This federal provision would ensure that law enforcement, as well as family members and household members of those who pose an immediate risk of harm to themselves or others, have consistent access to courts to seek ERPOs, and would enable continuity of enforcement of ERPOs across state lines. Federal courts have long been bastions of due process, and accordingly, this legislation includes strong due process provisions that strike the appropriate balance between protecting the rights of the gun owner and ensuring community safety. For example, the bill would allow an order to be issued pursuant to an ex parte proceeding, but only for a brief duration of 14 days. In the proceeding, a neutral federal judge must determine whether there is probable cause to believe that the gun owner poses a risk of imminent personal injury to himself, herself, or another individual by purchasing, possessing, or receiving a firearm or ammunition, and that the ERPO is necessary to prevent the injury. During that 14-day time period, the court will determine, after a hearing that includes participation by the gun owner, who may be represented by counsel, if a long-term order lasting up to 180 days is appropriate under a clear and convincing evidence standard. The petitions for these orders require a signed affidavit sworn to before the court, explaining in great detail why the petitioner believes that the gun owner poses a risk of imminent injury to himself, herself, or another person by purchasing, possessing, or receiving a firearm or ammunition. If the court issues an extreme risk protection order, the gun owner would have to surrender the firearms and the ammunition temporarily for the duration of the order. Also for the duration of an order, the fact of the gun possession and gun purchase prohibition would be placed in the NICS database used by the Brady Act background check system, so that gun dealers would not be legally allowed to sell guns to someone subject to an order while the order is in effect. This bill provides a sensible means by which an individual who is exhibiting dangerous behaviors can be prevented from possessing or purchasing firearms before tragedy strikes. According to one study, over 50% of mass shooters exhibited some warning signs before the shooting. The bill before us authorizes people who have serious concerns that someone they know poses an extreme risk to themselves or others to take the action needed to save lives. Today, this committee has the opportunity to build on measures that the House has already passed, including H.R. 8, the Bipartisan Background Checks Act of 2021. It is critical that we enact all of these bills. Every day in America, on average, 34 people are murdered with a firearm, and more than 183 people are injured in an attack. But while no other country in the industrialized world would tolerate such statistics, in fact, gun deaths in most of those countries barely crack triple digits annually. In the United States, it is accepted as a grim reality. Every day that we do not act is another day that families will mourn the loss of a loved one. Every day that we do not act is another day that our streets, our schools, and our houses of worship are less safe because dangerous weapons are in the hands of individuals who should not be legally permitted to possess them. H.R. 2377 would take meaningful steps to prevent gun violence tragedies in our communities, while at the same time protecting the due process rights of those individuals in crisis. I thank our colleague, Representative Lucy McBath, for championing this effort by introducing this bill, and I urge all of my colleagues to support this important legislation. Before I recognize the ranking member, I want to remind members once again that masks are required in all enclosed spaces. They must cover both your mouth and your nose. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. Last week it was parents. This week it is gun owners. Remember what we learned last week in that important hearing? We learned Democrats supported the Department of Justice setting up an open, dedicated line of communication for threat reporting. As we said last week, a snitch line on parents. The Attorney General engaged the National Security Division in this effort, and the only evidence the Department of Justice had for taking these actions was the letter from the National School Board Association, which 24 hours after our hearing last week, they apologized for. And it wasn't just your average apology. It was, we regret and apologize for the letter. There was no justification for the language included in the letter. We apologize for the strain and stress this situation has caused you and your organization. 2 apologies in 1 paragraph. I don't know if I've ever seen that. So last week it was going after parents based on a letter that has been apologized for in a way I frankly haven't seen around this town. This week, Democrats are going to take away law-abiding Americans' Second Amendment rights. Here's what this bill would do. It would deprive individuals, people who have neither been accused nor committed any crime, of their firearms without due process of law. By depriving individuals of their property and rights without having been charged, arraigned, or convicted of a crime, this bill violates constitutional due process rights set out in the 5th and 14th Amendments. This bill would flip the presumption of due process on its head. The accused person is deprived of the opportunity of defense or the ability to cross-examine the accuser. Individuals faced with an ex parte order would be forced to spend a considerable amount of time and resources on defense without ever being accused of a crime. And if the individual mounts a successful defense, the difficulty of having the seized property returned is a huge burden. Think about it. This bill requires a firearm owner to turn over the firearms or sell them within 48 hours. But there's no requirement in the bill for the government to return the firearms once the order expires or is no longer in effect. This means that individuals who seek the return of their property must take independent and expensive legal action to have the property returned by the federal government, the property that was taken in an unconstitutional fashion. More troublingly, this bill is predicated simply on the belief of third parties. Your neighbor doesn't like you, will now have a mechanism to get the government to take your Second Amendment rights away, to take your firearms away. This bill is about limiting American Second Amendment liberties. Make no mistake, this bill is all just a pretext for the Democrats to take guns away from law-abiding citizens. Think about this. Democrats defund the police, they label parents as terrorists, and now they're going to take away your firearms without due process. This is frightening. I hope we don't pass this legislation. I hope you vote no. With that, I yield back the balance of our time.
The gentleman yields back. I now recognize the ranking member of the Crime Subcommittee, the gentleman from Arizona, Mr. Biggs, for his opening statement.
I thank the chairman. H.R. 2377, the Federal Extreme Risk Protection Order Act of 2021, would deprive law-abiding Americans of their due process rights while taking away their Second Amendment rights. It permits a wide array of individuals to petition a federal court to apply for an extreme risk protection order to be issued to take away an individual's firearms when, if there's an issue at all, this should be a state issue and not a federal congressional issue. The person petitioning to take away the Second Amendment right could be a wife, an ex-husband with a grudge, an estranged sibling, a child, a parent, an ex-roommate who may be owed back rent money, or law enforcement. This bill provides a formula that is ripe for abuse of fundamental rights. Issuance of an ex parte extreme risk protection order would permit law enforcement to seize an individual's firearms without the respondent being afforded the right to a hearing. In fact, the firearms can be held by law enforcement for 2 weeks at least before the respondent will be allowed a hearing on the matter. An ex parte order can be granted if the court finds there is probable cause to believe that the respondent poses a risk of imminent personal injury to self or another individual by purchasing, possessing, or receiving a firearm or ammunition. That standard of proof is too low to be depriving law-abiding Americans of their Second Amendment rights. Some states have already enacted similar laws. In Connecticut, for example, nearly a third of all ex parte orders are overturned once a judge hears both sides of the story and considers all the evidence. What other rights are Democrats willing to throw out the window without due process protections? If you value the Constitution and the respect for individual rights and liberties, you should be offended by legislation that proposes to deprive individuals of their right to due process of law before their rights are eliminated and their property seized. This bill, I remind you, is not aimed at criminals, illegal aliens, or fugitives. This bill is trained on law-abiding Americans who are not prohibited by law from purchasing or possessing firearms. They should not lose their Second Amendment right without due process. If your goal is to reduce gun violence, disarming law-abiding Americans without ensuring their due process rights is not the solution. I yield back.
Gentleman,
Mr. Chairman.
Gentleman yields back. I want to first say I see members who are still not wearing masks. I want to put you on notice that you will not be recognized to speak if you do not comply with this rule. If you wish to participate remotely, you are welcome to do so.
Mr. Chairman.
For what purpose does the gentleman seek
Ask unanimous consent to enter into the record the memorandum sent from the National School Boards Association last Friday evening to its members where they apologized for the September 29th letter that was the catalyst for the Attorney General's action.
Without objection,
Mr. Chairman, I ask unanimous consent to enter into the record letter from the Ohio School Boards Association announcing it will no longer be a member of the National School Boards Association, quote, as a direct result of the letter sent by the NSBA to the President of the United States last month.
without objection. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2377, offered by Mr. Nadler of New York. Strike.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I now recognize myself to explain the amendment. The amendment in the nature of a substitute makes a number of changes to the underlying bill, many of which are minor and technical in nature, such as adding definitions of certain terms, and some of which are more substantive. For example, it clarifies that no fees would be charged to a petitioner or respondent with respect to an order. It also adds language to ensure that ERPOs are as available to Native American tribes as they are to other communities. The amendment also refines the factors that a court is to consider in deciding whether to issue an ERPO, and it stiffens the penalties for making false claims in petitioning for an order. In addition, the amendment expands the demographic data that is to be collected and reported concerning these orders, and then enhances the training that federal officers must undergo with respect to the use of ERPOs. All of these changes improve an already good bill, and I urge all of my colleagues to support the amendment. Are there any amendments to the amendment in the nature of a substitute? For what purpose does Ms. McBath seek recognition?
Thank you, Mr. Chairman. I move to strike the last word.
Gentlelady is recognized.
Thank you so much for holding this important markup so that we can take action on saving lives. Nearly 9 years ago, I lost my son Jordan to gun violence. And not a day goes by that I don't think about him. He was just only 17 years old, full of hopes and dreams for the future. Far too many parents know exactly that pain. And like many of them, I turned that pain into action, calling for change so that not another parent would lose their child to gun violence. Across the country, survivors, families, and advocates have demanded that we do more to save American lives. Some states stepped up, passing extreme risk protection orders, or as we call them, red flag laws, that empowered loved ones and law enforcement to take action and keep families safe before it's too late. But as a country, we didn't do enough. We haven't done enough. In 2018, we lost 17 more lives, including 14 more young people at the shooting at Marjorie Stoneman Douglas High School in Parkland, Florida. The world watched in horror as children the same age as my son Jordan, came streaming out of that school with their hands up in the air, terror on their faces. That is when I knew that we had to do more, and I decided to run for Congress. After Parkland, more states took action to save lives of our children and our families. Extreme risk protection orders are now available in 19 states and also the District of Columbia. These laws are life-saving tools to keep firearms out of the hands of those that pose a danger to themselves or to others. They have been passed by state legislatures controlled by Republicans and Democrats and signed into law by governors of both parties. And these laws are truly saving lives. And we American deserves access to this life-saving tool. And that is what my bill provides. Too often we are told that we must accept gun violence. We're told that no single piece of legislation can prevent every incident. And we are also told that instead of changing our laws, we must have more lockdown drills, more security guards, more bulletproof glass, more vigils for those that we have lost. But we also see time and time again that someone knew a shooter was dangerous. Someone knew the shooter had weapons. Someone knew the shooter was filled with violent thoughts, or even that a person was thinking of taking his own life. Too often someone knew, but no one had a tool to do anything about it. The bill that we're marking up today will guarantee nationwide access to this critical tool. With extreme risk laws at the state and federal level, we can prevent gun violence, including mass shootings, suicides, and all the horrific events that do not make our headlines. These events fill our calendars with reminders of those that we have lost, from birthdays that we still observe to celebrate the time that we had together, to memorials for victims lost to acts of hate. Today is one of those all too common days. 3 years ago today, a man entered the Tree of Life Synagogue in Pittsburgh and shouted, "All Jews must die," and opened fire. In the weeks before the shooting, he made anti-Semitic and xenophobic comments online. Just hours before the shooting, he posted an anti-Semitic remark and added, "Screw your optics, I'm going in." He killed 11 people and wounded 6 others, including 4 police officers. It was the deadliest attack on American Jews in the United States history. More than 100 people die each and every day as a result of gun violence. And every single day that we fail to take action, mothers and fathers across this country will live through the same nightmare that I have. Every single day that we fail to take action, siblings and spouses will feel the same agony, the same grief that comes with losing a loved one. More than 100 Americans a day, more than 100 families, 100 communities, 100 people. It is our responsibility to prevent this suffering, to bring an end to this constant heartbreak. Inaction is absolutely unacceptable. Today, we act to help those that are in crisis. We act to empower law enforcement, and we act to prevent the vigil for the loved one that we have lost. I thank my colleagues who have co-sponsored this legislation and the many advocates and survivors who continue to fight to end gun violence in this country every single day. I ask my colleagues on this committee to stand with me in supporting this legislation. Together, we have to save lives. We must save lives. The American public deserves that. and I yield back the balance of my time.
The gentlelady yields back. For what purposes Mr. Shabbat seek recognition?
Move to strike last word, Mr. Chairman.
Gentleman is recognized.
Thank you, Mr. Chairman. And I would first note, Mr. Chairman, that you already twice made note of the fact that tragically, some members aren't wearing masks. And that may be why some members, more and more, are participating in these hearings and markups in their offices where they don't have to wear masks, rather than in person where they still have to wear masks, despite the fact that many of those members already received the vaccine, 2 shots when Pfizer, if they participated there, and a booster if they're over 65 years of age or otherwise. So I would just note that this is all about posturing. We're not going to give it to each other at this point if we've received the vaccines, et cetera, et cetera. And I just would, I would hope that this committee and the speaker would revise this policy. We do want to be safe. We want to have this virus in the rearview mirror as soon as possible, protect the
Gentleman
public.
yield.
But at this point in
Would the
time, I
gentleman
just
yield?
heard, I'd be happy to yield.
Thank you. I'm not a microbiologist. All I can say is we're following the guidance of the attending physician.
Okay, reclaiming my time, I would suggest that that be revised. And the speaker has allowed herself to be dominant on a whole range of things. For example, keeping the fence up for months and months after it was required, and a whole range of other things as well. But anyway, Mr. Chairman, last week, this committee held a Justice Department oversight hearing in which the Attorney General, Merrick Garland, testified. And I and a number of my Republican colleagues at that time were very critical of the Biden administration and the Justice Department for essentially accusing parents of being domestic terrorists simply because they wanted to be involved in their children's education. The Attorney General's October 4th memorandum, triggered by the National School Board Association, is an example of the left trying to use the full power of federal law enforcement to shut parents up, to chill their protected First Amendment rights by intimidating them. Despite the National School Board Association's apology the following day for sending the misguided, ill-conceived letter in the first place, the Attorney General has not withdrawn his October 4th memorandum. This leads to the conclusion that the Biden administration's Justice Department maintains the position that it will use its federal police powers, which include the Patriot Act and the DOJ's National Security Division, to treat parents exercising their First Amendment rights at school board meetings as domestic terrorists. And this morning, the majority's theme of trampling on the constitutional rights of hardworking American citizens continues. But today, rather than the First Amendment rights, it's the Second Amendment rights that the majority wants to dramatically infringe upon. There's no question that our goal should be to keep guns out of the hands of criminals and out of the hands of individuals with mental illnesses. But this legislation is extremely flawed. It allows a seemingly unending list of individuals to petition a court to remove someone else's firearms merely based upon probable cause, which is a very low legal standard. What makes matters worse is that the individual seeking to have the gun confiscated can do it before giving the gun owner any opportunity to participate in the matter. This legislation clearly decimates due process rights by invalidating significant portions of the 5th and 14th Amendments. Due process is fundamental to the very existence of our justice system. It's unimaginable that this red flag bill proposes such a low evidentiary standard in an ex-parte hearing. It illustrates that the majority really doesn't care about the constitutional rights of American citizens and just wants to take away firearms from law-abiding citizens any way they can. I urge my colleagues on both sides of the aisle to reject this legislation and protect the due process rights of all American citizens to ensure that they can continue to exercise their Second Amendment rights as guaranteed by the United States Constitution. And with that, I yield back, Mr. Chairman.
The gentleman yields back. For what purpose does the gentleman from Rhode Island, Mrs. Cicilline, seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Thank you, Chairman Nadler, for bringing this important bill for markup today, and thank you to Congresswoman McBath for introducing this vital legislation. I remain in awe of your courage. It is maddening how frequently we hear that a shooter displayed warning signs of violence prior to a shooting and that no one acted. In the face of so many red flags, can we blame people for asking, why didn't anyone do anything? Unfortunately, the answer too often is because in too many states, there is nothing that can be done, no matter how troubling someone's behavior may be. On average, firearms are used in 64 deaths by suicide per day. 56% of mass shooters from 2009 to 2020 showed warning signs that they posed a risk of violence. The shooter at Marjorie Stoneman Douglas High School showed exactly these kinds of warning signs before he killed 17 high school students and staff. In fact, before the shooting, he'd been the subject of dozens of 911 calls and tips to the FBI, had posted content related to self-harm on social media, and his own mother reported his violent behavior over and over again to law enforcement. But despite all these reports, there was no way to stop him from possessing the automatic weapon that was used to kill 17 innocent people. Simply put, this bill allows a federal judge to temporarily keep a person at extreme risk of committing violence from possessing a firearm. The claims by my colleagues on the other side of the aisle that there's no due process is completely false. This bill sets forth detailed process, requiring notice and hearing, swiftly an opportunity for the individual deprived of the firearm to swiftly contest it, and strikes a balance between the Second Amendment right and the right of the public and other Americans to be free of the ravages of gun violence. People have a right to live in their communities safe and free from gun violence. That is a constitutional right of life, liberty, and the pursuit of happiness. So this notion that we should not have the ability in any way to limit violent and dangerous people who have exhibited tendencies to show they're a danger to themselves or others, that we simply have no choice but to allow them to access firearms and live with the consequences is ridiculous. It's wrong, it's constitutionally unsupportable, and the process in this bill sets forth exactly the right balance. Currently, 19 states in the District of Columbia have similar laws. In my home state of Rhode Island, we adopted such a law in 2018. It has been invoked 76 times between 2018 and 2020 and is known to have prevented multiple suicides. I'm tired of asking when it's too late. Why didn't somebody do something? We have the ability to do something. Today we are doing something, and we would not be here today without the thoughtful, consistent, and deeply committed leadership of Lucy McBath. And I want to thank Congresswoman McBath for this critical, common sense legislation that will save lives and will help us fight the epidemic of preventable gun violence. I'm proud to be a co-sponsor, and I urge my colleagues to support this. And in my final couple of minutes, I just want to suggest to my Republican friends on the other side of the aisle, this hearing is not about the refusal to support the police exhibited by so many Republicans in refusing to support the American Rescue Plan and refusing to address the violence against law enforcement that happened on January 6th and recharacterize it. That's not what it's about. It's not about the efforts to stem violence against educators, teachers, and school administrators and school boards. And it's not even about Attorney General Garland's explicit testimony under oath that, of course, the department recognizes the First Amendment rights of everyone and that parents aren't domestic terrorists, but that the FBI has a responsibility to keep communities safe. And so, despite what will be an ongoing effort to mischaracterize what this hearing is about and to make claims that are unsupported by evidence, this is about a very common sense proposal to protect people from the ravages of gun violence. When people have exhibited dangerous behaviors that indicate by clear and convincing evidence that that person is a danger to themselves or others, if we can't construct a piece of legislation that allows, in those instances, to temporarily remove that firearm with an opportunity for that individual to make their case to the contrary, then we simply are going to say there's nothing we can do. We have to live with the consequences of seriously mentally ill and dangerous people getting firearms, killing themselves, and killing innocent people. That is not a conclusion I'm prepared to accept. And so I end again by urging all of my colleagues to support this excellent piece of legislation. And again, want to say thank you to Congresswoman McBath for her extraordinary leadership, for taking a very painful, unspeakably painful personal experience, the loss of her son, and transforming it into action that will help millions of people be protected from the same kind of tragedy. And I thank you, and I yield back, Mr. Chairman.
For what purpose does Mr. Massey seek recognition?
I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, this red flag law that's being marked up today is unconstitutional, it's hurtful, it's redundant, and I'll walk through each of those here in the brief time that I have. First of all, it's unconstitutional. My colleague already conceded that 17 to 19 states have already implemented similar laws. That's because this is the domain of state law. This is not the domain of the federal government. In fact, the Supreme Court struck down the Gun-Free School Zone Act prior because they tried to use it, somebody tried to use it for a gun that hadn't been in interstate commerce. And so this bill already admits to its unconstitutionality because 2 places in the bill, it tries to allude to interstate commerce, and it knows that this has nothing to do with interstate commerce, so the authors of this bill. So it's unconstitutional because it takes the authority of the states, it violates the 9th and 10th Amendments in that regard, in addition to the Second Amendment. But more importantly, it violates due process. Our country has a rich history of protecting due process, where you are innocent until proven guilty. This bill turns that on its head. You are now guilty until you can prove your innocence. You are deprived of a constitutional right to protect yourself and your family until you can prove your innocence. This is ridiculous and unconstitutional. And here's why it's hurtful. Already, one of my colleagues on the other side of the aisle has said that this will prevent suicides. The problem is it doesn't prevent suicides. People who are having suicidal thoughts will not express those. If this bill they will not tell others that they are having these concerns about harming themselves, because this bill puts them in jeopardy. If they so much as tell a family member or a friend that they are having suicidal thoughts, then they know that their guns will be taken away by the federal government. So there's an incentive now for them to cover this up, to not disclose their thoughts, their hurtful thoughts, maybe to themselves or others. And this goes for police officers too, who know that if they lose their right to own a gun, then they're no longer employable, or security guards. So they're going to hold all that inside. They won't seek help, and you will have more suicides because of this, because this bill is going to presume they're guilty until proven innocent. Now, why is this bill redundant and unnecessary? Because every state in the union, all 50 states, have bills that are sometimes referred to as the Baker Act. In Florida, they call it the Baker Act. This allows the state government to go in and commit somebody to mental health facility, in most cases for up to 72 hours. What's the difference between that legislation that's been implemented at the state level and the legislation being debated today? The difference is that those bills on the books in all 50 states provide help to the person who is supposedly having thoughts of harming themselves or others, whereas this bill provides no help whatsoever. In fact, it goes in and agitates the person who may be having thoughts of harming themselves or others. So the state bills are already there. They're already being used. Again, it's called the Baker Act in Florida, but all 50 states have some form of this. And the difference between that legislation and this legislation is it provides help, but it also involves a mental health professional, which is not, that doesn't come into the equation here. And nobody's getting help from this bill. The money that's going to be wasted on hurting people, the money that's going to be wasted on this bill, wasted on taking away constitutional rights of law-abiding citizens who've done no crime. They're going to be convicted of a thought crime, basically, without a jury or a trial until they can prove they're innocent. That money should be taken and used to provide mental health assistance to the people who we are supposedly concerned about. Yet this bill does none of that. It turns our system of justice on its head by making people guilty until they're proven innocent. And if I may, because it's already been mentioned by 2 of my colleagues already today, we had Attorney General Merrick Garland in our committee last week. I'm still waiting on an answer from him. He refused to answer. He can answer this question. Were agents or assets of the federal government present among the crowd on January 5th and January 6th If they were they agitating for the protesters to enter the building? And if so, did any of them, of those federal agents or assets, enter that building? Merrick Garland said he can't answer that question. He absolutely can answer that question. He owes the American people the answer, and I yield back.
The gentleman yields back. For what purpose does Ms. Bass seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. It is far past time to pass common sense legislation addressing the public health crisis of gun violence in our country. I'm grateful to my friend, Ms. McBath, for her work on this issue, including on this legislation we're considering here today. I noticed she mentioned the slaughter at the synagogue a few years ago, and I know just a few days before that, there was another shooting of two individuals, two African-American individuals by a white supremacist. And a couple of days after the synagogue, there was another shooting at a yoga studio of somebody who wanted to specifically kill women of color. The simple reality is that extreme risk protection orders help make our communities safer. In my own state of California, researchers found that at least 21 cases where the state's extreme risk law was used to disarm people who threatened mass shootings, including a car dealership employee who threatened to shoot up his workplace and a high school student who threatened to commit a mass shooting at a school assembly. Maybe with this, if this legislation had been enacted, maybe the massacre in El Paso could have been prevented. As of the time that study was published, none of the threats identified were able to be carried out in California. Extreme risk protection orders work, which is why we cannot leave these reforms solely up to the states. We need to give everyone the same tools to prevent gun violence, no matter where they live, as we know all too well that state borders are not barriers to violence. It is essential that we work together to address this issue. That's why I'm proud to support this bill. I look forward to it passing out of committee, and I urge my colleagues to support the bill as well. I yield back.
The gentlelady yields back. For what purpose does Mr. Fitzgerald seek recognition?
Thank you, Mr. Chair. Strike the last word.
Gentleman is recognized.
H.R. 2377 is a bill written by the Biden administration and the Attorney General that takes property and gun rights away from law-abiding gun owners without an opportunity to appear in court. This is exactly what happened in EP versus Lakeland Police Department, where an appellate court ruled that the plaintiff's due process rights were violated because the court chose to hear this case virtually instead of in the court facility listed in that order. Red flag laws violate Second Amendment rights without due process. Just to make the point that this is a state's issue, when I was in the Wisconsin State Senate, I was part of a charge against red flag laws proposed by Governor Tony Evers, and we adjourned the governor's special session on that issue. We cannot sacrifice our constitutional rights. H.R. 2377 is egregious in its due process violations against law-abiding gun owners, and I will oppose it. I urge my colleagues to vote no on H.R. 2377, and I yield back.
The gentleman yields back. For what purpose does Ms. Jackson-Lee seek recognition?
Strike the last word, Mr. Chairman.
The gentlelady is recognized.
Mr. Chairman, I could not be more proud of this body, this committee, and more proud of Congresswoman McBath. As the chair of the Subcommittee on Crime, Terrorism, and Homeland Security, I'm particularly proud of all of our members' commitment to just laws. And the law before us, the bill before us, is no less just. The only thing I see in the work of Congresswoman McBath is that she has sought justice. Justice for victims, justice for families who beg to have a way to deal with individuals who they love and care for, but they know provide an extreme risk. Violation of the Constitution? I'd like to see that clarified. This in no way undermines the Second Amendment. Frankly, if one reads literally the Second Amendment, it is to stand up in a militia. Subsequent interpretation has made it a singular standard of godlike behavior. So I rise with great enthusiasm for this work. With this committee's consideration of H.R. 2377, the Federal Extreme Risk Protection Order Act, we are responding to our citizens across the country who've been urging the enactment of gun violence prevention legislation, but particularly families who cry out, "Help me, help my loved one." In recent years, we've mourned the loss of life resulting from so many mass shootings that have shocked our nation. But we must recognize and acknowledge that gun violence is a daily problem that extends far beyond these terrible mass casualty murders. Every day, 316 people on average are shot in the United States, and over 38,000 people die each year from gun violence in this country. And every year, nearly 8,000 children and teens are shot in the United States. School shootings have become a pandemic and an epidemic. Each shooting is a tragedy with devastating impacts on individuals, families, and communities, and the problem of gun violence does impact all of our communities, urban, suburban, and rural. We must do all we can to prevent each of these tragedies, and there is more we can do. Expanding the availability of extreme risk protection orders is one important step we must take. General Garland willingly acknowledged the importance of these laws. He is the Attorney General for all of the United States, and they have shown that as the Department of Justice has worked for all rights of all Americans. 19 states and the District of Columbia have passed extreme risk protection laws, which have proven to be effective. In California, one study found that extreme risk protection orders were issued under that state's law in 21 instances where there were concern of a mass casualty event. After Connecticut enacted an extreme risk protection order law, the state experienced 14% reduction in its firearm suicide rate. That is crucial. People killing themselves, families needing help. In Indiana, the number of suicides declined 7.5% in 10 years after it enacted its extreme risk protection order. While some states have enacted these laws, many have not. But all of our citizens deserve to be safe from gun violence no matter their state of residence. That is what the responsibility of the federal government is, and that is what, under Chairman Nadler, the responsibility of the Judiciary Committee is, to bring justice to all. And that is why we need a national law, which is what H.R. 2377 will provide. When family or household members or law enforcement officers can demonstrate evidence that an individual presents a serious threat to themselves or others by use of a firearm, they should have the opportunity to seek an extreme risk protection order before our federal courts, allowing a judge, this is not snatching away your constitutional rights, rights of privacy and beyond, due process, however you would analyze it, allowing a judge to weigh the evidence and issue an order when appropriate. I was here for the tragedy of Connecticut. And so I commend Representative Lucy McBath for her work on this bill and on the other issues related to gun violence. I ask my colleagues to support this important legislation and to make us safer from firearm violence whether it's in our homes or on our streets. It is our duty to do so. For all of those who believe in law enforcement, who recognize the most recent important day in our law enforcement community, honoring those who fell in duty, in the line of duty. If you care about those individuals, you will support this legislation. If you care about 26 children murdered and slaughtered in Connecticut in an elementary school, where the individual who, in fact, came and not only killed them, but killed himself, you would understand the basis of these and this law. You would understand that it is now imperative that we pass the Federal Extreme Risk Protection Order Act, and I'm very proud to support it at this time. With that, Mr. Chairman, I yield back.
Gentlelady yields back. For what purpose does Mr. McClintock seek recognition?
To speak on the amendment.
The gentleman is recognized.
Thank you, Mr. Chairman. This is what I don't understand. Yes, there are people, particularly those in a mental health crisis, who pose a danger to themselves or to others. That's very clear. And that danger is not just limited to firearms. I mean, there are plenty of examples of attacks by such people with knives, axes, machetes, baseball bats, strangulation. Suicide's not limited to firearms, jumping off a bridge or out a third
The gentleman
story
yield
window.
for a moment?
Yeah.
I would just observe, as a matter of experience, that an attack with a firearm is much more likely to be lethal than an attack
Oh,
by
no, there's
a baseball bat
no
or
question about
knife or
that.
whatever else.
But the point is, there are many cases of attacks by people in a mental health crisis that don't involve a firearm, but are just as lethal and just as deadly to the victims. The point is that if the person poses a danger to themselves or to others, they need help. And simply removing firearms from the occasion is not getting them that help. The fact is, every state in this country has commitment procedures to do that. And those commitment procedures respect a person's due process rights. They take expert testimony of trained psychiatrists. They respect the due process rights of the accused. That's the appropriate course to take when we identify someone who may pose a danger to themselves or to others. We're said this doesn't trample on rights, this respects due process. Well, due process includes the right to contest charges, the right to face your accuser, the right to present evidence on your own behalf, the right to cross-examine witnesses. This measure allows for none of these rights. This measure allows the government to seize firearms, which are protected by the Second Amendment to the Constitution, with none of these rights. The seizure's done without the accused even knowing that the process has taken place. Only in retrospect can they then contest the confiscation. This is the brave new system of justice that I'm afraid the left would impose on us. Sentence first, verdict second. Either a person's a danger to themselves and to others, and we should get them the help they need, respecting their due process rights, as we do in every commitment proceeding that takes place in all of the 50 states, or they don't pose a danger to themselves or others, and the government has no place denying them their constitutional rights. I yield back.
The gentleman yields back. For what purpose does Ms. Escobar seek recognition?
Move to strike the last word.
Gentlelady is recognized.
Mr. Chairman, on June 27th, 2019, at 11:15 in the morning, a worried mother called the Allen, Texas Police Department. She shared with them her concern about her son, who owned an AK-47. She was worried about her son owning this weapon of war because of his age, maturity level, and lack of experience handling the weapon. His mother was transferred to someone at the department whose response was that her son was legally allowed to purchase the gun. Weeks later, on August 3rd, that young man drove 10 hours to my community of El Paso, Texas. On a sunny Saturday morning, he walked into a Walmart, one of the busiest in town, while families were shopping for groceries and school supplies, and he began what would be the deadliest targeted attack against Latinos in modern American history. He confessed to wanting to slaughter Mexicans and immigrants, and he used anti-immigrant rhetoric used by some of my colleagues on this very committee, calling our presence in the United States an invasion. 23 innocent lives were taken, dozens were injured, and my community was and still is devastated. Mr. Chairman, I seek unanimous consent to enter into the record the ABC News article, "Mother of Alleged El Paso Shooter Called Police About Son Owning Assault Rifle."
Without objection.
Mr. Chairman, Ms. McBath, thank you for your leadership on this issue, and thank you for bringing this bill forward to our committee. To my colleagues, when we talk about rights, I ask you, what about the rights of my constituents to live free from fear of being massacred? And for those who want us to punt to the states, I can tell you that we cannot depend on state government to protect the health, safety, and welfare of our constituents. And example number one is my own state of Texas. After the massacre, Governor Greg Abbott came to my community, came to El Paso, and he promised he would act on gun violence prevention. He gave my community his word. His word turned out to be worthless. Even after the massacre, after that empty promise, Texas now has some of the loosest gun laws on the books in the country. So no, the state cannot be trusted as long as there are elected officials willing to trade the lives of their constituents in exchange for NRA money and votes. So it's up to us to ensure our communities are safe. And I'm proud to support this common sense legislation. Thank you, Mr. Chairman. I yield back.
The gentlelady yields back. For what purpose does Mr. Tiffany seek recognition?
To speak on the bill, Mr. Chairman.
Gentleman is recognized.
Thank you very much. So we heard in the chairman's opening remarks, he said, only 14 days. That was the quote. And so only 14 days to give up your rights. It's reminiscent of about 18 months ago when it was 2 weeks to stop the spread. Is this the standard we use now, that it's only 2 weeks that you give up your rights? We all know if you give them up, you give your freedoms up for a day, it may be a lifetime. So one of the things that's being left unsaid, there's a fair amount of talk here today in regards to the school shootings, which are really horrific actions that have been taken. But in one of the South Florida shootings, the FBI was notified. They ignored the actions that they ignored what was happening and the actions they could have taken. An FBI that seems to have lost its mission here in America. They should have been paying attention to things like this where it truly has to do with the safety of the American people. The other thing I would say is we have a statute in Wisconsin, it's called Chapter 51, and my colleague from Wisconsin alluded to it earlier, which handles involuntary commitment. The state of Wisconsin is handling this just fine. And what I would say to the federal government in regards to an issue like this is, butt out. This is used rarely, but it's used appropriately in Wisconsin. And it was written in a way that was constitutional in our state. So I just say to the American people out there, you're seeing a pattern in this Congress in the short 10 months that it's been here. And I sure hope the American people are paying attention. We have a couple bills before us right now that are being negotiated. Trillions and trillions of dollars are going to be spent. What's one of the key provisions in it? 87,000 new IRS agents. Boy, doesn't that make you feel good. $10,000 in transactions. Oh, it went up from $600 to $10,000. Don't worry, we have compromised. $10,000 in aggregate transactions in a year. There are very few people that will not meet that threshold. We have an attorney general last week that wanted to deny people their First Amendment rights. And I would say to my colleague on the other side of the aisle, then why did he write that memo saying that the FBI should work with local law enforcement? Why did he write that memo then, if he didn't really mean to put the jackboot of the federal government on parents who simply attend those local school board meetings? By the way, I'm one of those parents who has attended school board meetings over the last 18 months with my friends, my neighbors, and with my constituents. And as a former town board member who was in a few ruckus meetings here and there, there's an easy way to deal with it if people get out of control, is you call your local sheriff department. Federal government, butt out. The states can handle these situations. And by the way, while talking about the actions of the Attorney General, where he contemplated, let's put the full weight of the government, the FBI, the Department of Homeland Security, even the Security Division of the Post Office. Did you all know there's a Security Division of the Post Office? The school boards asked for all of it, and the Attorney General was willing to grant that for them. And I would point out, an August member of this committee who is no longer here, whose picture is hanging on the wall right over there, wrote a lengthy article about using the Patriot Act against parents in America. That was never contemplated. I urge you to read that article if you doubt at all what could happen if the Attorney General gets his way with parents across America. Let's be real clear. Federal extreme risk protection orders are a fancy name for red flag laws, and they are a very simple thing that the left has been trying to do in this country for decades, and they will continue to do it, and that is simply a gun grab. This bill is written for gun grabbers across America. We must vote no to protect Americans' fundamental freedoms, whether it's the First Amendment, the Second Amendment, or all of them that have been written to protect us all. Thank you. I yield back.
The gentleman yields back. For what purpose does Ms. Scanlon seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Thank you. I'm so proud to support Congresswoman McBath's bill, the Federal Extreme Risk Protection Order Act. I'm also proud to align myself with parents, family members, mental and public health experts, law enforcement, in seeking this common sense gun safety measure. You know, about 2/3 of all gun deaths annually are suicides. In Pennsylvania, gun suicides, I'm sorry. In Pennsylvania, that's about 1,000 people we lose every year to gun suicide. 17 veterans die by suicide each day, and in Pennsylvania, 70% of those veterans who commit suicide use a firearm. In the states that have enacted extreme risk protection order laws, those measures have proven to be an effective tool in preventing firearm suicides. And studies have shown that a large number of people subject to these acts actually seek and receive mental health treatment as a result of these interventions when they may not have otherwise. We've heard from some of our colleagues' stories of folks who are not seeking to kill themselves, but to kill others. We have to take action. The situation as it stands now is not tenable. I have to reject the crazy mischaracterizations we're hearing across the aisle of these acts being unconstitutional. Challenges to extreme risk protection acts generally are not succeeding, and this bill has been carefully crafted to comply with the Constitution. I also am shocked at the idea that one would substitute deprivation of individual liberty to commit people to mental health institutions, as has been suggested, as some kind of preferable alternative to the short-term removal of dangerous weapons from someone who is at risk to themselves. And as for this idea that there's no due process consideration here, that's also a fiction. There are multiple levels of due process available here to someone who is adjudged, first of all, upon sworn testimony by a judge to that there's probable cause that such a person might be a risk to themselves or others because of the guns they possess. And then there is opportunity for that person to challenge that judgment. I mean, there's multiple levels here. There's high standards. I think it's a carefully crafted bill, and we need to move forward. In the past 4 or 5 years, we've seen 40% of our states and the District of Columbia pass some version of extreme risk protection acts. That's not enough. In Pennsylvania, we've had both Republican and Democratic legislators propose such legislation, but the number of our legislators who are still enthralled to the NRA and refuse to even pass constitutional, common sense gun safety measures is still so strong. So if the states are not going to act to protect our citizens, then Congress must do so. At a time when mental health issues are on the rise, it's more important than ever to create a federal extreme risk protection order law. We need to ensure that people nationwide have access to this life-saving measure to help those in their lives who may be threatening harm against themselves and others. We have to give people an avenue that if they see something, they can say something and have it be heeded, unlike what we saw in the Parkland shooting, unlike what we saw in El Paso. In so many cases, suicide or a mass shooting is preventable, and this bill provides short-term protection to those in crisis so they can get the support they need and keep themselves, their loved ones, and their communities safe. I urge all of my colleagues to support the bill, and I look forward to passing it out of committee today and moving it to the House floor as quickly as possible. I yield back.
Gentlelady yields back. For what purpose does Mr. Issa seek recognition?
Chairman, I move to strike the last word.
Gentleman is recognized.
Chairman, let me start by asking unanimous consent that the syllabus or the extract of the Supreme Court decision of District of Columbia et al. Versus Heller be placed in the record.
Without objection.
Mr. Chairman, earlier one of our senior members made the constant and pervasive statement, one that I want to make sure does not be allowed to stand in the record, that the Second Amendment is about militias. In the Heller decision, decided in June 26, 2008, when both the chairman and that member were here, it was made clear that, as I'll quote, number one, the Second Amendment protects an individual right to possess a firearm unconnected with the service in a militia. I don't think you can be any more unambiguous than that, and I hope that this is the last time that I have to hear somebody constantly saying that our Second Amendment right is a right of the National Guard or something of the sort.
Would the gentleman yield for question?
Of course, Mr. Chairman.
Thank you, but isn't it also true that in the Heller decision, Justice Scalia said that reasonable firearms regulations were constitutional?
Mr. Chairman, you're absolutely right. This one is not a reasonable firearm legislation. One of the reasons that what we're considering with 2377 today is not reasonable is that it does not even begin to pass the, if I would call, the proper and appropriate test. Mr. Chairman, in one of your opening statements today, at a sidebar actually, you made the case when you said you were not a microbiologist. Mr. Chairman, a federal judge is not...
That is certainly true.
It remains true, as does it for me. But Mr. Chairman, a federal judge or a magistrate, more likely, is in fact not a psychiatrist or a medical doctor. The lack of a due process is paramount, and if you're going to somehow preempt due process, you certainly need to find an appropriate skilled professional. An estranged family member, an angry neighbor, or just a political enemy is in fact not an expert, nor is a federal judge. So we start off with that defect even before we get to the other defects of this bill. Certainly 14 days is an awful long time to be denied your Second Amendment rights. I will close my statement and say that for the author of the bill, some years ago, about the time the Heller decision, my nephew was here working for Congressman Kucinich. He worked for about 4 months for him and thoroughly enjoyed it. He was a college graduate trying to figure out when and where to go to law school. A few months later, he killed himself by hanging. He had problems that had been diagnosed. He had been under medical care on multiple occasions. Suicide is a terrible tragedy in America, and it is one that we must take seriously. It is also one that is not easily prevented. The tools available for someone to take their own life, unfortunately, do include jumping off a bridge, hanging oneself, an overdose of any number of drugs, or worse. So although they're constantly talking about either suicide or homicide, let us understand that mental illness and the need to do it, which is not primarily the committee's jurisdiction, certainly needs to be taken seriously. And in this case, among the many defects in this bill, the lack of any consultation with somebody who could make a qualified decision as to the individual, even if this bill reached out and said, an EMT has seen this person, a police officer who has supplemental training, anything that would allow for that skilled decision for a short period of time could potentially, at least at a state level, reduce the harm that this bill might do. But in the absence of that, I cannot support it and will not support it. I will close with this. I do not stand with the NRA. the NRA stands with all of us who believe that the Second Amendment is a critical element that has served us well for 240 years in protecting all of our rights. And I yield back.
Gentleman yields back. For what purposes Mr. Cohen seek recognition?
Thank you, Mr. Chairman.
You move to strike the last word?
Yes, sir.
Thank you. The gentleman is recognized.
I want to commend Congressman McBath and the other members who've worked on this bill. There are two options on this bill. One option is to vote for it, pass it, save some lives. The other is to offer thoughts and prayers. We've had enough thoughts and prayers. We continue to have thousands of victims of gun violence, people killed. Suicides, yes, but homicides. In Memphis, we've had quite a few lately. Man went into the grocery store, killed one person, shot a dozen others. Student went in elementary school or junior high school, student, like 8th grader, went into school and shot another student. 3 students outside of high school were shot just yesterday by another. If there is probable cause, which is a fairly, it's not the highest burden by far, but it's a burden that has to be met, and it means there's a probable cause, means a pretty good thought that somebody's going to do something, that somebody is going to commit an act of violence, homicide, suicide, whatever, against somebody else. And a judge, federal judge, not a justice of the peace, but a federal judge who is not a gun grabber, finds that probable cause exists, that this person's going to do harm, and has the weapons ordered to be taken, with the person having a right to come in within 72 hours and have a hearing and show the reason why they are not what was alleged, due process is involved, then that should occur. If there are issues or concerns, I would submit just a baseball, the tie goes to the runner. In these type of situations, the tie should go to person that would otherwise be the victim. You can't bring a life back. When they're gone, they're gone. Show me a case, please. We didn't have them in Memphis, where a good man or woman with a gun protected and stopped the use of a weapon. That canard doesn't occur. That just dog won't hunt. It doesn't happen. And show me a case, we've talked about people losing their Second Amendment rights through these procedures. Show me a case anywhere, in any of those 16 states or anywhere, where somebody had their guns taken and then they were assaulted and shot by someone and couldn't defend themselves because their guns were taken from them. I don't think you'll show me any, and if any, not many, cases where anybody, because they didn't have their Second Amendment rights gun with them, were a victim because of a red flag taking of their weapons, temporary taking. These are people on the cusp of committing a violent act against a person, themselves, or an animal for that matter, and those entities are being protected. We need to protect people. We need to protect people, not just give them thoughts and prayers. One of my colleagues and friends said something about being without your Second Amendment rights for 2 weeks. Go to your psychiatrist and let him tell you what Freud said about that. You can deal with it for 2 weeks. This is a good bill. It'll protect and save lives. There are not cases that you can show that indicate that these laws in 16 states in the District of Columbia where they exist have caused people to lose their lives because they didn't have those weapons. there are situations where it can be shown that it protected somebody's life and health and/or a pet's life or an animal's. So I'm proud to support this bill. I think we all should. Time is over for thoughts and prayers. It's over for just lining up and being for the NRA. And the NRA, they went bankrupt last year, spending a lot of money on their executives, a lot of money on themselves. They like to sell bullets and guns, and that's what they're there for. I yield back the balance of my time.
The gentleman yields back. For what purpose does Ms. Fishbach seek recognition?
Mr. Chair, I move to strike the last word.
Gentlelady is recognized.
Mr. Chair, this bill undermines Americans' fundamental rights and contradicts the foundational pillars of our justice system. It appears to be a step toward universal gun registration, which is a violation of Americans' right to privacy. Without a federal gun registration database, how will officers know whether the respondent owns any firearms to begin with, or how many firearms are supposed to be confiscated? This bill could turn law-abiding gun owners into criminals without a crime ever being committed. What will happen to a law-abiding gun owner who has committed no crime if they refuse to hand over the firearms without due process? Let's be honest about what this bill really is. It's an attempt by my Democrat colleagues to use the federal government to intimidate gun owners, the same way they are using the federal Justice Department to intimidate school parents. Police departments around the country are already stretched thin. Officers have been leaving in droves as calls to defund departments and demonize the profession continue from some Democrats. As Democrat-run cities continue to tie the hands of police officers and cut their funding, we have witnessed crime rates go up and arrest rates go down. In Minnesota, for instance, the clearance rate for human trafficking crimes were down from 72% clearance rate in 2019 to only 18% in 2020. Nearly every type of crime saw a decrease in clearance rates in the last year. Not because our brave police officers are not doing their job, but because they are not being given the tools they need. Instead of helping police enforce our laws, Democrats want to use our police to enforce their political agenda. Mr. Chair, I oppose this bill adamantly, and I appreciate the opportunity. Mr. Chair, I yield back.
The gentlelady yields back. For what purpose does Ms. Dean seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. San Jose, Boulder, Atlanta. These are only some of the high-profile mass shootings from this year alone. In San Jose, we lost 10 people. In Boulder, another 10 lives were lost. In Atlanta, the lives of 8 people, including 6 Asian American women, in one day, taken by gun violence. These are just a mere fraction of the mass shootings from this year. The dozens of mass shootings this year alone underscores the relentlessness of this epidemic. The problem is that we have normalized these incidents. We now anticipate the next one. Congress must do more. We must do more to stop this. Here are the tragic numbers in this country. At least 39,000 people a year, 100 people every single day, die of gun violence. 23,000 of those die by gun suicide. Gun access triples suicide risk. And this shameful global distinction, Americans are 25 times more likely to be killed by a gun than in any other high-income country. Domestic violence victims are 5 times more likely to be killed by their abuser if there is a gun in the house. So you can imagine I proudly lend my support to Representative McBath's federal extreme risk protection order. And I thank her for her courage, her thoughtfulness, and her wise crafting of this legislation. Although red flag laws already exist in 19 states and in Washington, D.C., that's not enough. Gun violence is a national epidemic that requires a national response. When people are in crisis and pose a threat to themselves or others, Those closest to them are the first to notice and see the warning signs. Extreme risk laws allow for people and law enforcement officers to respond with immediate action. These laws allow family members or law enforcement to petition for a court order to temporarily bar people in crisis from accessing firearms. As members of Congress, we have a duty to reduce all forms of gun violence: community violence, mass shootings, domestic violence, and suicide by firearm. This law is a powerful step in the right direction toward addressing this epidemic, and it is an epidemic. And yet, I can see that those on the other side of the aisle who are still quibbling over masks don't even recognize the threat of a pandemic, where we have lost, over the course of these last almost 2 years, on average 1,000 people a day, and still quibbling over masks. I feel very differently. I feel we have a responsibility to protect life, whether it is from a pandemic or an epidemic like the scourge of gun violence in this country. I thank my colleague and friend from Georgia for being such a champion, and I ask my colleagues to support this. I yield back.
Gentlelady yields back. For what purpose does Mr. Gohmert seek recognition?
To strike the last word.
Gentleman is recognized.
Thank you. I was struck by a friend from Tennessee's words that basically we can pass this bill or we can provide thoughts and prayers. John Adams said, this Constitution was intended for a moral and religious people. It is wholly inadequate for the government of any other. This nation has always provided individuals with access to guns, but this nation has not always had so many mass shootings. What's the difference? Well, I would submit that when you go back to the 60s and the movement to teach children in school that there is no moral right or wrong, there is no right or wrong. It's just what you feel, what you concoct in your own young head without guidance from a responsible adult. That's what is right. Whatever you think, don't tell a child no. The difference is we've gone for decades now allowing less and less teaching about moral right and wrong. There's a great deal of confusion. This nation does have a choice. Because just as John Adams said, if we're not going to go back to teaching that there is moral right and wrong, then we will need to get rid of the Second Amendment, not this mamby-pamby cutting off the Second Amendment around the edges, but you'll just have to eliminate it because nobody understands that it's not a good idea to shoot people just because you feel bad or you think it might feel good, so just do it. The choice is getting back to teaching a moral right and wrong, or we can continue to mock Americans who pray before they act and seek God's guidance. Some pray for wisdom. I've been praying for wisdom since I was 6. I believe the Hebrew Bible that says God will grant wisdom as you ask. The problem is he doesn't say when, so it's obviously more than 50 years after you start asking sometimes before it's granted. But there is wisdom in seeking wisdom before acting. That Hebrew Bible I believe in says the wisest man that ever lived was made wise because he asked for wisdom. Perhaps there's wisdom in not mocking those who believe in prayer, mocking, belittling, stirring up sentiment against those who believe in and seek the wisdom and assistance of God could someday even lead to shutting down churches in a time of national emergency. Oh, yeah, we just did that. But it could also lead to discrimination and even violence against those who seek God and pray. But we've already been having that. So we can continue to eliminate prayer and continue to belittle those who pray and seek wisdom before they act. Or we can eliminate the rights that we currently hold dear, not just second. You're going to have to eliminate freedom of speech. Oh, yeah, we've already been doing that. But we can be eliminating freedom of assembly. Oh, yeah, we've been doing that. Okay, well, we can continue to eliminate the rights the Constitution has given us, or we can get back to having parents care more about what's taught in school and making sure children in school are taught there is a moral right and wrong, and not moral relevance or equivalence of whatever suits the young mind that we're supposed to be training. This is a critical issue that goes to the heart of this very country's existence. Let's get wisdom before we start striking down our rights. I yield back.
The gentleman yields back. For what purpose does Mr. Raskin seek recognition?
I move to strike the last word, Mr. Chairman.
Gentleman is recognized.
Well, I was moved by the gentleman's critique of moral and factual and scientific relativism, which struck me as a great description of the conversation we're having in America right now about the 2020 presidential election, which Joe Biden won by more than 7 million votes, 306 to 232 in the Electoral College. And still, we have a former president of the United States and a large part of his party, which continued to deny that and claim that he won the election. So I can't think of a better example of precisely the syndrome he's talking about, of people denying the existence of an objective reality. But Mr. Chairman, I want to thank the gentlelady from Georgia for introducing this superb legislation. And if she would yield for a question, I just want to ask her this, because I know that there are 19 states, including my state, Maryland, and the District of Columbia, that have adopted red flag laws. And I want to know whether they actually do work to save lives. Do we actually have warning in some cases that a person might be prepared to carry out a violent gun attack on other people, either a mass attack, or to harm themselves, or to harm other people?
Well, thank you so much, Representative Raskin, for those questions. And, you know, to my knowledge, in the 19 states that have enacted red flag laws, no, there have not been any that have been struck down simply because they recognize that the number of homicides and also suicides continue to drop. They decrease because, you know, the safety measures that are being put in place. And actually, we know that in 80%, about nearly 80% of the perpetrators that are actually creating kinds of statements, making statements, are acting with very dangerous behaviors. They're actually kind of letting people know in advance, their families, their loved ones. They're letting people know in advance their intentions to do harm in these mass tragedies. So,
well, I thank the gentlelady very much for both of those points. One point being that in a majority of the cases where someone's going to carry out a mass attack, like the Tree of Life cinema, the Tree of Life synagogue attacks, the attacks in Charleston, South Carolina, El Paso, Newtown, Connecticut, these massacres, there are reasons to believe they've either told people or there are reasons to believe that they will act. And so the red flag laws help to empower family members and other intimate people to come forward to say, we've got a real problem, we've got a danger, and it's working. But you've also pointed out, Ms. McBath, and I appreciate this very much, that with all of the very loose talk about the Second Amendment here, not a single one of these statutes has been struck down. despite the fact that lots of them have been brought to court. And why is that? It's for the reason that the chairman indicated before. And it is precisely the Heller decision, which did reject the militia-based concept of the Second Amendment, said that individuals have a right to weapons for the purposes of self-defense and for the purposes of recreation. But of course, said Justice Scalia, they are subject to all kinds of reasonable regulation, the same way that the First Amendment is too. I mean, there are reasonable time, place, manner restrictions for the First Amendment. You can protest outside of the White House, but not at 2:30 in the morning with a loud sound system that's going to make it impossible for people to sleep. That doesn't violate the First Amendment. That's not a regulation that violates the First Amendment. It's consistent with the First Amendment. And these laws have been found to be perfectly consistent with the Second Amendment. So we should stop confusing the public about that. Mr. Ice's point was that the judges are not doctors or psychiatrists, but the statute doesn't refer to mental illness. It doesn't require the diagnosis of a specific mental illness. It simply references the standard of whether a person poses a risk, an imminent risk to themselves or to other people. That's precisely the same standard that governs in the involuntary commitment civil statutes, which our colleagues in the minority are praising with respect to taking people to court and then to involuntary commitment. By the way, those statutes are still very much part of the law, so it's not an either or. If people can be involuntary committed for inspection and interview and diagnosis for several days, certainly we have the much lesser right to take away their guns so they don't hurt themselves or other people in the meantime. This is excellent legislation. I want to thank Ms. McBath again for her leadership for this common sense, perfectly constitutional legislation, which has been adopted with great success around the country. I yield back, Mr. Chairman.
Thank you, Mr. Raskin. The gentleman having yield back. Mr. Bishop, for what purpose do you seek recognition?
Move to strike the last word, Mr. Chairman.
So granted, 5 minutes.
I wonder whether Mr. Raskin would yield to a series of questions.
By all means.
Thank you, Mr. Raskin. Just in reviewing the law and just sort of to take little of the heat and just discuss exactly what we have before us, I wanted to ask you if my reading of it is right in several respects, and a couple of questions that come from that. You're a constitutional law expert, as I understand. First of all, as I read it, the petition provision on page 4 says that essentially any family member or state or local law enforcement officer anywhere in the country can go to federal court to seek this kind of order. Isn't that right?
But anyone who has knowledge of the relevant facts of the person posing an imminent danger to himself or to others.
Yeah, and anywhere in the country. And of course, a lot of state courts that deal with domestic violence and all these things. So this would open up the federal courts to that. My understanding is the federal court system is has limited jurisdiction under the Constitution. It's limited to cases arising under federal law or disputes between citizens of different states, basically. I mean, there are a couple of things we could get into, but that's basically right, isn't it, Professor?
Yeah, you need to have federal jurisdiction.
Okay.
And the law would create the federal jurisdiction.
So this law, which confers jurisdiction on the federal court, would also be the federal law under which it arises for federal jurisdiction purposes?
Well, this is how all federal laws work.
Usually you have a substantive law created, and then separately Congress confers jurisdiction on federal courts, right?
Well, usually there's a jurisdictional component in the federal statute itself, establishing federal jurisdiction.
All right, so the way federal jurisdiction is founded here, if I understand correctly, is this language on page 12 about interstate commerce, and it says, and that's where it says, the court shall order the respondent to surrender all firearms and ammunition that the respondent possesses or owns in or affecting interstate commerce. That's what I think someone referred to it in their questioning earlier. I guess my question for you, Mr. Raskin, as I read it is, how does the mere ownership or possession of a gun, how can that be in or affecting interstate commerce?
Well, as I understand it, what we've done with all federal firearms regulations since the Lopez decision is to create that language that you just referenced. In other words, the statute says that the guns must relate to interstate commerce.
I'm asking a much more basic factual question. You might ask me if I were in your law school class, and that's to say, if I possess a gun or I own it and nothing else appearing, how does that affect or how is that in interstate commerce? In the interstate commerce is commercial activity between states, isn't it? Or involving the pattern of interstate, of business between states, among states?
Well, my understanding of this legislation is that it tracks the federal constitutional standard established in the Lopez decision,
Okay.
which said,
It must be a more complicated answer that can just be given factually. So let me just move on to something else then. As I was looking at pages 7 through 9, this is not only about a temporary deprivation for a few days or something like that. The court can enter an order, a long-term order for 180 days, and it looks like on pages 10 to 11, the court can renew the 180-day orders forever, potentially, without ever subjecting any of this to a jury or requiring any conviction of any wrong. Is that correct?
with notice and opportunity to be heard, and a judge deciding on a probable cause standard that the person presents an imminent risk of injury to himself or to others.
Wow. So he doesn't get
probable cause-
he doesn't get a jury trial, and he doesn't ever have to be convicted of a crime, or she, and can lose their rights potentially indefinitely and potentially permanently by virtue of the extension of these orders every 180 days, right?
Well, that's right, because no one's being put in jail and no one's being convicted of a crime.
And that's
remember, this is
justifiable?
a prophylactic civil standard. It's a protective regulatory statute.
Let me ask one last thing as long as we're talking. In the last hearing with Attorney General present, and this was also something we were concerned about, people's rights, you said that Donald Trump, quote, has given license to the darkest impulses in right-wing politics and given rise to conspiracy theory-driven mob violence, not just at state capitals, like we saw in Lansing, Michigan, which was a dress rehearsal for the January 6th attack, but also it's in schools and school boards across the country. The School Boards Association has apologized to parents across the country for attributing to them the characteristics of domestic terrorists. Do you want to retract that comment, Mr. Raskin?
Retract what? There are lots of cases of people threatening school board members and teachers taking place across the country. I mean, are you denying that?
Yeah, I am. I yield back. I'm out of time.
All right.
The gentleman yields back. For what purpose does Ms. Garcia seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, it's been really interesting sitting here now for almost a couple of hours listening to some of the remarks being made, particularly from across the aisle. To hear statements like, this is just ridiculous and it's on its face unconstitutional, is, to me, what's ridiculous. It's the comments that I keep hearing, because this is really a very simple bill that, quite frankly, we passed this last time. This was not some scheme that the President and the Attorney General, as has been again alleged by members of the other side, to take guns away from people. I mean, this bill actually was looked at last time. I supported it last time. I support it again. I thank my dear friend and colleague, Lucy McBeth from Georgia, for bringing it to us again, and congratulate her with her passion and commitment on this issue. And I'm here to strongly support this bill. These arguments about due process, I mean, I'm a former judge. I kind of know a little bit about due process, and basically it's an opportunity to be heard. The person will have an opportunity to be heard. They will have an opportunity before a judge before it's final. So I don't understand some of these arguments. Due process is a word that gets thrown around a lot, but if you read the bill, the due process protections are in there. This is not any unilateral action, and frankly, it's not a bounty scheme. This whole idea that, well, anybody in the country can file on this. No, it's not. It's very different than the bounty scheme of the abortion law in Texas, where anybody in the country can file it. I mean, we've already had one case of someone in jail in Arkansas file one of those cases. This is someone who has to witness and see the behavior and pattern of the danger that someone could have to themselves or others. They have to attest to being able to say that they saw this and they fear that this person actions may lead to violence and to further harm to himself, herself, or the community. And I think it's important to note that the last poll that I saw, 77% of the people in America support the red flag laws. And this whole idea that, well, it's a state's thing, let me tell you something. Not only am I a former judge, I'm also a former state senator from Texas. And I can tell you that we can't pass a red flag law in Texas. And in Texas, when I was there, and we argued a red flag law on the floor, and I debated a red flag law on the floor of the Texas Senate, we were argued against it, saying, well, you know, the Congress should do something about this because this is about all the states. We shouldn't just do something here in Texas. So, you know, I think you got to be careful what you ask for and what you allege. And finally, let me say this. You know, I'm a native Texan, and like a lot of native Texans, I have a gun. I still have a gun. But I grew up on a farm, and my family taught me how to use it. They taught me how to respect it. And mine was never a handgun or an automatic weapon that shoots people. Mine was always a .22 rifle or a .410 shotgun. And that was meant for hunting. And yes, I've gone hunting many times. And it was meant to put food on the table because we were poor. If we went out there and didn't hunt and kill something, then we ain't gonna eat that night. So that's how I learned about guns. It was for sometimes sport, but a lot of times about putting food on the table. It was never meant to be, my dear friend, Ms. Macbeth, to kill people, to shoot people. In fact, I don't know how to use a handgun. I'm a terrible shot with a handgun. But I'm pretty good with a .22 rifle, close to being in any Oakley, I would even say. But you gotta have parameters. This is not about taking guns away from people. This is about taking guns and keeping them out of the hands of the wrong people. So with that, Mr. Chairman, I do want to introduce an article from NPR entitled "Americans, Including Republicans and Gun Owners, Proudly Support Red Flag Laws." And as a gun owner, native Texan, I too support a red flag law. With that, Mr. Chairman, I yield back.
Without objection, and the gentlelady yields back. For what purpose does Mr. Roy seek recognition?
Move to strike the last word.
The gentleman is recognized.
Well, as the gentlelady on the other side of the aisle knows, I too live in Texas. Raised my son, daughter to respect firearms. We shoot them frequently on our property. We shoot semi-automatic weapons on my property. I teach my children how to use them safely. I teach them what they're used for, why we have the ability to have firearms. And yes, we use it for hunting. My son shot his first deer.
Would the gentleman yield for a question?
Briefly.
Yeah, very question. What do you use semi-automatic weapons for?
I use semi-automatic weapons to kill hogs. I use semi-automatic weapons for sport and shooting on our property, but I also have semi-automatic weapons, and I'm getting to the point.
Thank you.
Because a semi-automatic weapon is a weapon that you can use for self-defense. It is a semi-automatic weapon that you can use to defend yourself against home invaders, but also, let's be clear, against tyranny. The gentlelady is talking about the Second Amendment in the context of hunting, as if my rights are reduced in the Constitution to a .410 or a single shot or lever action .22, as if that was what was expressly put forth as how we're supposed to be defending ourselves.
Gentleman yield again?
And let me go ahead and finish my time, sir, unless we want to add more time.
Very, very quickly, question.
I need more time. Will the gentleman give me another 30 seconds?
Yes.
Okay, I'll yield.
You said that you could use a semi-automatic weapon to fight tyranny.
Sure.
You mean you'd use it against American troops?
The very existence of the Second Amendment is designed purposefully to empower the people to be able to resist the force of tyranny used against them to step over their natural rights given to them by God. That is why the Second Amendment exists. That is very specifically why the Second Amendment exists. And let's be very clear about that. Let's rewind the clock a little bit, as I know at least several justices have written in Supreme Court opinions, but about what life looked like in the 19th century and what the government was doing to remove the ability of either slave owners or, importantly, freed blacks, or importantly, whites who even stood up in defense of blacks or against slavery, and the efforts by the South and the efforts by the strong arm of government to remove their ability to have firearms. That is an absolute, undeniable, documented, historic fact in our country. As written by Robert Verbruggen in the National Review, and I'm happy to submit this to the record without objection, he writes, the heart of the problem is that in an effort to stave off rebellion and maintain the racial caste structure that had developed under slavery, state and local governments refused to respect freedmen's constitutional rights. Crucial to the South's efforts were gun control laws that applied to blacks and blacks alone. This does not show that, and it goes on further, I'm going to take too longer, where it goes into the South's campaign against black gun ownership, not surprisingly, began long before the Civil War. 2 slave rebellions in the 1820s stoked whites' fears, and in response, many legislatures amended their laws prohibiting slaves from carrying firearms to apply the prohibition to free blacks as well. When the government, and he writes further, and I agree with this, when the government has the ability to forbid gun ownership, it has the ability to render groups it dislikes helpless to defend themselves, regardless of whether modern gun control accomplishes its purpose of reducing crime. And for the record, there is no evidence it does. And I agree with that as well. This is so inherent to the very conversation we're having. My colleagues on the other side of the aisle just blithely dismiss due process. A former judge even saying, arguments about due process, you have the opportunity to be heard after. You have the opportunity to be heard after your rights have been taken away. That's the key issue here. We are absolutely destroying the bedrock principle that your rights are given to you by God and that you can't just have to go to the government to ask permission to exercise those rights. And when you
would the
do
gentleman
that,
yield for a question? Could I ask Mr. Roy a question? Would you yield for a second?
I need to finish up my time. I already have a few seconds left over from the chairman. I'm happy to engage with you in colloquies later. And I would point out that my colleague from Maryland, again, just sort of rolled over the fact that it was very expressed in the Supreme Court's ruling that the Second Amendment protects an individual right to possess a firearm unconnected with service in a militia. My colleagues like to continually try to connect that to militia service, but we all know that what a militia looked like in 1775 and 1776. I appreciate that the chairman gave me a little extra time in light of our exchange and questioning. I yield back.
The gentleman yields back. For what purpose does Mr. Gates seek recognition? Gentleman is recognized.
Thank you, Mr. Chairman. And I must take note that as we're having this discussion today, the Attorney General is in the Senate, and he was just asked by Senator Grassley, given his testimony in the House, that there was no basis for his decision to create the school board task force in the absence of the letter from the National School Boards Association, and given the National School Board Association's apology and retraction of that letter, would the Attorney General be dissolving the school board task force? Astonishingly, he said he would not, which kind of gives up the game, that this was never about safety for educators or school board members. It was all about chilling parents' participation in the decision-making process that they were aggrieved by, a decision-making process that often embraces pseudoscience, that is reactionary, and that pushes critical race theory, which causes people to hate each other as a consequence of their own skin color or the skin color of the other students or the other professional staff that work in our schools. Speaking of chilling, it certainly seems that there hasn't been an adequate response to the argument that Mr. Massey made earlier in debate that if this law were enacted, there would be a disincentive for people to seek mental health care. We don't want to live in a country where if someone needs access to that care, that they would be discouraged from doing so, fearing some broader deprivation of their rights. And while I know this must be a very difficult day for my colleagues who have personally felt the impact of shootings and mental health that results in suicide, we have to look at solutions that are actually tailored to solve the problem, not just bills that could potentially exacerbate those problems. And it seemed as though I would love to hear from my colleagues how you would expect people to reach out and get mental health care that they might need if they think that on the back end of that care, they would be deprived of their gun rights Mr. Chairman, I heard earlier one of our colleagues say that there's just not a circumstance where a good guy with a gun is helpful when there's a bad guy with a gun, and I seek unanimous consent to enter into the record a ABC News piece entitled "Florida School Shooting Heroes Teary Tale, I'm No Hero, Folks."
Without objection.
And in this case, in Bay County, Florida, there was a violent person with a gun that showed up to a school board meeting and opened fire on the school board and the superintendent. And by the grace of God, he was unsuccessful in harming those school officials, but it was an off-duty police officer who was there in a security capacity, who had a firearm and was able to neutralize that shooter. So I think that in my state and in many others, broad deprivations of Second Amendment rights and sort of the de-gunifying of society won't lead to better safety outcomes. I would also take
Would the gentleman yield for?
Well, I'm making an additional point, Mr. Cohen, and I know you were clear in your comments that you wanted examples from Memphis. So I hope you'll indulge an example from my community where
Thank you. We
guns were
vacation
helpful.
there.
What's that?
I say we vacation there.
Well, we're always blessed to have you. And we hope you come frequently and know that there'll be a lot of folks that are utilizing their Second Amendment rights. It'll be honored to keep you safe. The other note that we've heard a lot about is hunting and self-defense. And I would just note that the Second Amendment is not about hunting and it is not about self-defense. Our founders believed to curate the right balance of liberties in our country so that it would never become necessary to engage, God forbid, U.S. troops with firearms from our citizens. But if we maintain a well-armed citizenry, that creates a balance of liberties and it retards a tyrannical government from being able to be overly forceful against our citizens. So I hope we'll understand that historical framework when debating the Second Amendment. If there are those who think we ought to repeal the Second Amendment, that we don't need armed citizenry to maintain liberties, then let's debate on those terms, not with these sort of paper-cut assaults on the rights that our citizens enjoy and that I believe are granted quite explicitly in the Constitution. And let's also hope that as the American people evaluate the actions of the Department of Justice, they see that a piece of evidence can be the basis for a policy. That evidence can be debunked and the policy can persist nonetheless. It harkens back to the Russia hoax where there was this big lie that Donald Trump was a Russian agent, and then that animated all this activity from the Justice Department that impaired the liberty of Americans, and it seems as though they're continuing on that trend, but now instead of targeting Donald Trump, they're targeting parents who love their kids who show up at school board meetings, and the Attorney General made clear today that he intends to continue doing so. I yield back.
The gentleman yields back. We have a number of bills that will soon be on the House floor, followed by floor votes. Therefore, the committee will stand in recess until immediately after the conclusion of those votes, at which point we will entertain amendments to this bill. The committee stands in recess.